Have a seat.
Alright, thank you.
Assalamualaikum and good morning everyone. Today we are present here for the complaint by Jan De Nul Sdn Bhd. And before we proceed, allow me to briefly introduce myself. My name is Nurulhusna and I will be the arbitrator for this session. And first and foremost, I would like for all of you to pledge with me. You solemnly swear to tell the truth, the whole truth and nothing but the truth. So help you God.
I do.
Okay, thank you. Before we begin, I would like to each of you to introduce yourself.
Alright, thank you, Madam Arbitrator, and also the respondent sides. And my name is Amiru, and I will be the counsel for the client, Jan De Nul, which is Claimant in this arbitration session. And my client has instructed me to represent them in this field.
Okay. My name is Azrul and I will be the counsel for Vincent and Central of Malaysia Properties in Sdn Bhd, which is the respondent in this arbitration.
Okay, thank you to both counsel. Okay, for now, before we proceed, I would like to stress that impartiality and independence of the arbitration tribunal. We have already stated in our disclosure reports, which I believe the parties have already furnished with my personal qualification, financial background and other personal interests, which I believe will not in any way affect our impartiality, and that we don't have any financial, fiduciary and other interest in the controversy or case to be decided, or in the result of the proceeding, or has any personal bias which might prejudice the right of any party to a fair and impartial court. Also, I just want to inform to the parties that I'm not a judge, but the outcome of this session is final and binding according to Section 36 of Arbitration Act 2005. So before that, may I ask if any of counsels to this matter know of any potential conflicts between the arbitrator and any party or counsel in this matter?
No?
No.
Then for now, let's hear the facts of matters from the claimant, maybe.
So unless there is an objection, the claimant want to start first.
If there is no objection from the respondent, please proceed.
Thank you, Madam. So, in this session, Jan De Nul Malaysian Sdn Bhd, which I will mention as JDN in this session, was a private company limited by share incorporated in Malaysia. And also, Jan De Nul Group, which I will mention as Sofidra in this session, was the ultimate holding company of JDN, incorporated in Luxembourg. The respondent, which is Central Malaysian Properties Sdn Bhd, which I will mention as CMP in this session, awarded the project to JDN for its construction, and Sofidra was the guarantor guaranteeing the due performance by the JDN of its obligations. And the relevant contract was executed by the parties on 23rd March 2010. But however, works could not start as planned due to the respondent's delay in meeting its initial financial and payment security obligation. And then works only started on 8th October of 2010 after Vincent, the substantial shareholder of the respondent, executed a guarantee agreement in his personal capacity, guaranteeing the due and functional performance by CMP of its obligation under the contract. However, by the end of October 2010, CMP again in default of payment under the contract. And on 19 November 2010, my client JDN issued a notice notifying CMP, the respondent, that it had defaulted in its payment progress. But however, CMP failed to remedy the default payment. Moreover, sadly, I want to inform Madam and also the respondent that something disastrous happened at the site on 12 November 2010, where much of the reclaimed platform gave away and moved southward, resulting among others in the loss of one life, which I will mention as RFI disaster in this session. And as there was no appropriate response from the respondent, my client JDN had to terminate the contract on 2nd December 2010.
Okay, so Claimant person, what are your claims?
Alright, regarding the claim, my client Jan De Nul Sdn Bhd wants to claim for progress payment as stated in the contract, and also we want the respondent responsible for the RFI disaster that occurred on the project site.
Okay, thank you, Mr. Amiru. Now let's hear the facts and claim from the respondent person, Mr. Azrul.
Okay, thank you, Madam. Okay, right. On our side, we agree with all the facts that was given by the claimant. However, there are some claims that we want to emphasize here. First, we are not here because we are not trying to delay the payment. We are not trying to avoid the payment, but we are trying to delay. We are trying our best to pay it, but we are not trying to pay it on time. Okay, that's the first thing that we have to clarify. Second, I would like to inform that the claimant has terminated the contract, which is giving us a very hard time because as the result of the termination of the contract, we have to find another contractor who are willingly to continue the project. Okay, therefore, we from the respondent would like to claim for the compensation from the claimant for the termination of the contract. Thirdly, we are not the one who is responsible for the RFI disaster. That's all from our side.
Okay, before we proceed, are parties possible for an amicable settlement?
As previously, no.
No.
Okay, if there is no agreed solution, we may proceed to the arguments to substantiate our claim. And the claimant may start first.
Thank you, Yioun. So, Mr. Azrul, you agree that it is in the clause in the agreement that Central Major Properties Sdn Bhd has the obligation to pay if there is progress by my client JDN in the project. This is the contractual agreement. Madam Arbitrator, you may refer to clause 7, para A until para B at page number 5.
Thank you.
And this is for the respondent side to be referred.
Yes, I agree as stated in the agreement.
Mr. Azrul, is this the real agreement between parties?
Yes, Madam.
So, it is true that your client did not pay the progress payment?
Madam, as what I mentioned earlier, my client is understand that he is the right fact that the respondent did not pay yet, but on the intention, not the intention to avoid the payment at all. Furthermore, there is no clause governing the exact date of progress payment. However, suddenly the claimant had terminated the contract.
Then why don't you give any response to my client notice on 16 November 2010 regarding the defaulted progress payment? Madam, this is the state notice as I mentioned.
Madam, there is no enforcement of law regarding the notice. Our client did not has the obligation to respond to it. So, in fact, there is also no clause that which govern stating about that.
Madam, that does not mean that the respondent can delay the progress payment, as my client have already met the criteria in delivering the progress in the project.
Okay, alright, Claimant, please move to your next claim.
Alright, thank you, madam. Let's move to my client's next claim. Next, regarding the disaster that happened at the site on 1st November 2010, where much of the reclaimed platform gave way and moved southwards, that resulted, among other, in the loss of one life, my client, the Jan De Nul Sdn Bhd, want the respondent to be liable because they are one who awards the project, and therefore they should be responsible towards all the employees on the sites.
that's not how it works. My client has awarded the project to Jan De Nul, and therefore Jan De Nul has absolute power and control on the project, including the site. Jan De Nul should take all the safety measures, including risk management and occupational safety.
Mr. Amiru, later you should provide any legal document in order to make the respondent liable, because generally, whoever has the control on the project site, he will be liable for anything that happens on the project site.
Alright, I'm sorry, madam. And I think that's all from the claimant side for now.
Thank you, Mr. Amiru. Mr. Azrul, you may proceed for your defense and counterclaims.
Okay, thank you, madam. Okay, let me continue. Okay, now I would like to ask Mr. Amiru several things. Is it true that Jan De Nul, which is based in Luxembourg, is the ultimate holding company of Jan De Nul Sdn Bhd?
Yes, it is.
So, do you aware that Jan De Nul Group is the guarantor on the behalf in guaranteeing due performance to the obligations?
Yes. Right.
Also, in the contract of due performance, it also includes occupational safety at the site during the construction took place. Do you aware of that?
I think no.
Oh, it's okay. Here with me is the contract of due performance that was signed by Mr. Chee, okay, the representative of the Jan De Nul Group. In clause 8 of the contract, it mentions clearly that CMP will not prepare any damages in compensating if any accident occurred is from the negligence of the contractor.
Can I get a copy of the contract?
Oh, sorry.
Thank you.
Okay, let me continue. Based on the routine of occupational safety, is it required to do the daily report of routine checking at the site? Is it true?
Yes, it is true.
Okay. Do you have the report of occupational safety from 8th November 2010 to 12th November 2010 with you?
No, unfortunately, I didn't prepare for that.
It's okay. Because the said report does not exist. Because your employee failed to do so. Okay, here is the sample of the report that was made by your employee long time ago.
Just give me one for my response.
Okay, you get it? Okay, so based on this contract, it is clear that CMP is not the party that should bear the compensation that took the life of the labor. So it is Jan De Nul who is liable to this case. Okay, now I would like to ask one more thing. I would like to stress one more thing. Okay, about the termination of the contract. So, Mr. Amiru, we are never intended to unpay the payment as agreed, but we only pay it late. So, we are very shocked with your decision to terminate the contract, and it gives CMP a very hard time. So, madam, we are really consider that we are entitled to the compensation to be paid as the termination of the contract.
However, Mr. Azrul, I think you should be aware that Jan De Nul has never breached any clause of the agreement, as it does not mention any payment should be made to CMP when the termination is made by the client.
Madam Arbitrator, that's all from me.
Okay, based on the fact entered contract agreement and other documentary evidence submitted by the both parties, and the arbitral tribunal resolved the issues for the composition and responsibility upon the RFI disaster. JDN was fully responsible for it, and for the termination of contract on JDN was validly terminated. And lastly, regarding the issue of the arbitration fees and expenses for the station, shall bear fully by both parties. I think that's all for arbitration. Thank you for your cooperation.
Thank you, madam. Thank you, Mr. Amiru.
Hello, sir. Yes. Yes, I know. Don't worry, sir. It's just an alternative dispute resolution, a settlement outside the court. Yes, we still can fight in the court, sir. for setting aside the award of the arbitration? Yes. Okay, like this, sir. First, we will file to set aside the award under section 37, subsection 1, paragraph A, subparagraph 5 under the Arbitration Act 2005, and submit to the High Court that the award contains the decision on matters beyond the scope of the submission to the arbitration. This is because when we argue about the outstanding progress payment, the arbitrator was more likely to entertain the issue of the contract termination only. And somehow, moreover, we will also argue under section 37, subsection 1, paragraph B, subparagraph 2, and also section 37, subsection 2, paragraph B, subparagraph 2 of the Arbitration Act 2005, that we submit that the award was incomplete with natural justice and also public policy. This is because we also suffered due to the delay payment of progress by Central Malaysian Properties in Myanmar. Like that. Yes, like that. So, are you okay with that? If that, I will catch you later. Alright.